Don't you just love how lawyers try to paint violent defendants as having mental issues or have mental episodes? Well, this violent defendant had 12 misdemeanor convictions and 4 current pending convictions, 6 felony convictions, prior revoked probations, a long history of violence, and has done heinous acts while in jail. Do you think Judge West should let this guy see the light of day? Well, let's sit back and see how this trial plays itself.
All right. Kevin Alfred, Mr. Lewis, cause numbers 24 DCCR 1291, 1292, and 1143. Good morning, sir. Are you Kevin Alfred?
Yes.
Mr. Alfred was previously in court, entered pleas of guilty in 3 cases, 2 assault on a peace officer, 2nd-degree felonies, 1 harassment by a person in a correctional facility, a 3rd-degree felony. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Well,
Any additions or corrections to that report? And in addition, I have received a packet that you all should have received also of incident reports from the Jefferson County Jail. Have you also had an opportunity to review that? All right. And it looks like the agreement was for a cap of 15 years in prison in each of these cases with dismissals in the other, is it 2 or 3 cases? 3. Okay. The obstruction or all 3 obstruction or retaliations would be dismissed, correct? Okay. Mr. Lewis, you may proceed.
Judge, this is a situation where my client suffered from some severe mental health issue. Just from my time representing him, time from the beginning to now, just appearance-wise, totally different person. Now being medicated and sober and everything like that. He definitely self-medicated. But I believe when he's going through these issues with his mental health issues, even, trying to self-medicate anything does not correct the issues, it only makes it worse. And then just from the evidence that was presented or that we had from the cases at question, you can see that this was somebody who was going through some serious issues during those times. Now, as far as the jail issues, I know that seems to be a big issue as well. If you look at the dates on those jail issues, most of them around when he was first brought into custody, while he was still going through detox and getting acclimated to medication and things of that nature. So he was still going through a difficult period at that point, even when he was going through that. And probation even pointed out in the PSI report to be someone that really a rehabilitative type situation that will be better for him in his incarceration. It's a big ask in asking for some type of communication with mental health caseload and things of that nature. He's more than willing to comply with whatever. I think he's at an age where he's tired of the cycle and wants to try to take advantage of whatever may be available to him to try to fix this issue so he can be in a more stable situation and environment. I think the time he has been on his medications and sober these last few months have given him a different insight. And Judge, that is what we're asking for, that, he's able to try to take advantage of some of those things I think would be very important for him. I think even from the PSI report, you see these are issues he's had all the basis since a child, towards the mental health issue.
Judge, obviously I disagree completely with what the defense attorney is saying in this case. His history, 12 misdemeanor convictions with 4 currently pending. This will be his 4th, 5th, and 6th felony convictions. He's been given probation. He was revoked before able to complete successfully the probation. He's had a long history of violence, and some of the things he's done while he's in jail are heinous. The lewd conduct, the words, the throwing feces on more than one corrections officer showed what kind of person this man is. And I think 15 is probably a little weak. That's the most that we can do in the cabinet.
Mr. Alfred, do you have anything to say, sir? No. So, Mr. Alfred, your attorney makes some good arguments because, and I see the dates, and I do think that there's been a change. It seems like in the jail since you've been on some medication. The issue with me, for me though, is that you've had some opportunities to get some help in the past. You were given probation, that was revoked. You got out of prison, you reoffended, got a 6-year sentence, and couldn't have been out very long when you did what you did here.
Right from the start, this courtroom feels tense. We've got a violent past versus a medicated present. One side says danger, the other says redemption. So, who's Judge West gonna believe, the rap sheet or the rehab story?
You know, I mean, golly, I'm not really sure what to do. Because Mr. Smith is right. I mean, you deserve every bit of 15 years for what you've done. You really do. What you did to the officers, what you did in the jail. I guess what is sticking out for me is that all of that nonsense in the jail stopped when you started taking medication in the jail. So, do you agree that you need medication?
Yes, man. That's another thing that I wasn't able to get my medication. I was like, I was dealing with society too, and like my mind was playing tricks on. But I don't take nothing. Once I got medicated, I even feel like I know what's going on.
So I think what I'm going to do, Mr. Alfred, is give you an opportunity that you probably don't deserve. But if you take advantage of it and you stay on medication, it appears that you can just live. I mean, you've got training. You had some good jobs in the past. You're not somebody that quit school. You just need to stay on your medication. And what I'm going to do today is give you an opportunity to do that. And I'm going to give you some tools up front to hopefully help you do that. I can assure you that if I do this today and you don't follow through with what you're supposed to do, I would anticipate that Mr. Smith will remind me of this, and he probably won't even have to. But here's what I'm going to do. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. I'm going to find sufficient evidence in each case to find you guilty. In cause number 24, DCCR 1291, I'm going to defer all proceedings and place you on probation for a period of 10 years. You will be ordered to follow all of the rules and conditions of probation, and I'll talk about some of those specific ones in just a minute. Cause number 24, DCCR 1292, also find sufficient evidence to find you guilty. However, I'm going to defer all proceedings for a period of 10 years, place you on probation. Cause number 24, DCCR 1143, also find sufficient evidence to find you guilty. However, I'm going to defer all proceedings, place you on probation for a period of 10 years. In each of those cases, I'm going to order a $250 fine. I'm going to order in each of the cases that you enter and successfully complete the special needs track of SafeP. That gives you help for two things: the drug abuse that you're using when you're not on medication, and also it'll help you stay on your medication, and you'll get counseling for all of that. So you're going to have all of the tools that you need when you get out to be successful, stay on your medication, stay out of trouble. And if you don't do that,
classic defense strategies shift the focus from crime to condition. They're saying this isn't evil, it's illness. But here's the catch. In law, mental health doesn't erase guilt. It just changes what justice looks like.
The reason I deferred these cases instead of a straight probation where you were convicted is because in 2 of those cases, if you violate, I can sentence you anywhere in the range of punishment, which is up to 20 years. So that cap of 15 years is gone. I have the whole range of punishment. You're ordered to comply with any and all recommendations of MHMR, whoever you end up with when you get out, of SafeP. That includes if they say you need medication, you have to take medication. If you stop taking your medication, it's a violation of your probation. You're going to be back in here. You're going to end up going to prison for a long time. Do you understand?
Yes.
If you get to SafeP and for whatever reason, you think that it's going to be a good idea to act up in SafeP the way that you acted up in our jail, you will be back here on a motion to revoke before you ever hit the streets. Do you understand? It appears that that shouldn't be an issue. You haven't had an issue since June of last year and you got on medication, but I want to make sure you understand that you have to treat everyone with respect, follow the rules in our jail and in SafeP, and then you should be able to get out and again have the tools and the resources. You'll be on probation. You'll get to go to Spindletop. There won't be any excuses of I couldn't get my medicine and stuff like that. Do you understand? Do you have any questions?
12 misdemeanors, 6 felonies, and throwing feces at officers, that's not just bad, that's beyond rehabilitation territory, be honest. If you were the judge, would you risk giving this man probation? Again, drop your take in the comments.
I'm handing you the trial court certifications in each of your cases that shows these were agreements that I followed, and so you waived your right to appeal. I wish you the best of luck, sir. Thank you, Mr. Smith, Mr. Lewis.
This is where the bench gets heavy. You can see the judge's heart and head at war. She's heard the excuses before, but this time the medication seems to be working still. How many chances can one man get before mercy turns into regret? And there it is, the switch flips. Even he knows the meds are the only thing standing between sanity and chaos. It's rare you see this much self-awareness in a defendant. The question is, can he keep it once he's free?